Good afternoon, and thank you for joining us. I'm Robert Baylor, Director of Communications at NUCA. Welcome to our first NUCA Construction Law webinar. First, before we begin, some webinar housekeeping for attendees. Today's webinar will be recorded. It will be available on NUCA's YouTube channel and on our Construction Law webinar webpage, both of which can be accessed via nuca.com. All participants are muted upon entry. Phone participants can use *6 to mute and unmute themselves. Questions will be asked at the end of the presentation. To ask a question, you can submit a written question at any time using the chat feature, and I'll read them at the conclusion of our discussion. Or you can unmute yourself and state the question directly. Now let's get started. Last year, NUCA's legal committee decided to hold in 2023 a construction law webinar every other month to discuss with NUCA members current legal topics affecting the utility construction industry and our members' business operations. These discussions are a very popular part of the committee's meeting at the NUCA convention, so we're opening up these seminars to the entire membership through NUCA's webinar program. We also welcome your suggestions on future topics as well, too. The committee's first webinar will discuss utility identification and relocation issues. The unfortunate reality is most contractors experience delay, extra costs, and sometimes the assessment of liquidated damages for unmarked, mismarked, and late utility relocation. Our speakers will discuss strategies to minimize these utility problems. Tom Olson and Sean Farrell are well known to NUCA members as voices of authority on construction law. Tom is chairman of the NUCA Legal Committee and practices law in Minnesota as founding partner of Olson Construction Law, PC. Sean provides legal counsel to NUCA of New Jersey and is a partner at Cohen Segalius, PC in Philadelphia, Pennsylvania. Thank you, sir. Thank you all for joining us today on this NUCA webinar. Tom, I turn the webinar over to you.
Great. All righty, ready to rock and roll with the first slide here. That's good. So, as a starting point, our presentation is based upon the experience that Sean and I have not only in our respective states, but representing contractors throughout much of the country. I mean, it's fair to say that, in terms of the likelihood of encountering unmarked, mismarked, late utility relocation, it's on the level of death and taxes. I mean, three things, that are going to be an unfortunate aspect of life. So the question is, if it's a regular part of what you do, what's our strategy to either prevent it, minimize it, or otherwise get paid when the impact of that occurs? Let's go to the next slide. Okay. I mean, the problem that we have here is the culprit ain't one of the contracting parties to the project. In other words, when an owner sets up its plans, its specs, it's going to rely typically on a design one call to talk to the utility company to get utility information. So the project owner and the consulting engineer working on behalf of the owner is only as good as the information that it gets from the utility companies. So to the extent that you get inaccurate utility information, the problem is what do we do insofar as the culprit typically is the utility company, a non-contracting party, and the impact is so great. In order to submit low bids, you can't have idle iron it. You can't have reduced productivity. You're bidding on the basis of anticipated production based upon what you know. And that can't include typically the impact of late utility relocation as well as unmarked and mismarked utilities. So the question is, how do you protect yourself against that? And as a starting point, it's important to really appreciate just exactly how significant this problem is. Again, let's go to the next slide, please. I could give you a whole host of reports that addresses, but suffice it to say, federal highway as well as other numerous federal nationwide studies have recognized that the leading cause of delay, disruption to highway heavy construction around the country is unmarked, mismarked, late utility relocation, by far. This is just one of many studies that I can give you insofar as this is an issue that Sean and I have been assisting contractors around the country. So we know it not only from what we've read, but firsthand experience. Okay, next slide, please. It's important to recognize, and I think so often what goes unreported, unrecognized is it's not just a question of dollars and delay, but also safety. This is from a federal report. Striking a utility line occurs nearly every minute somewhere in the United States. Does that blow your mind? That's how significant it is. And, you know, and the impact of striking that line, besides dollars and delay, I mean, not only can cause injury, but can and does cause death. I mean, so we can't underestimate the scope of the problem insofar as it affects not only our bottom line, but the very health of our people that are working for us. Okay, next slide, please. It's important to recognize, and I want to communicate this again, having dealt with it on a ground level for so many years. The reason we have a problem is this: the X and the Y information, which is to say the horizontal information, is inaccurate. Okay, it's just the way that it is around the country. Number one, the problem of inaccurate horizontal information is magnified by the fact that, whether you know it or not, utility companies do not track the Z, which is to say the vertical location of the utilities. So when project owners are designing jobs, at best are designing on the basis of inaccurate X and Y, i.e. horizontal information, and no Z information, i.e. the vertical location of the utilities. Helps you have an understanding then of why we have as a regular basis a problem with unmarked, mismarked, and late utility relocation. Okay, next one. Gotcha. So in order to craft a strategy, we need to understand why we regularly have inaccurate and incomplete utility information. I had occasion to bring a successful lawsuit against CenturyLink. I think it's the third case in the country, hold the utility company liable for providing inaccurate utility information in response to a design one call. But it blew my mind when I was taking the deposition of the gentleman that was in charge, I think for 26 states for utility information for CenturyLink, what he stated under oath. And if you look at this, it will blow your mind. The actual location, and I quote sworn testimony, of utility could vary by plus or minus 1,000 feet in any direction. What? If that's the baseline of utility, and again, CenturyLink, one of the big ones around the country, telling you how accurate the information is, that's a real problem. I like it. The utility may actually show up on the wrong side of the road. And I think the last point, and I summarized a bunch of deposition testimony, but the last one blew my mind, which is, although public owners around the country, city, county, state, DOTs, are almost entirely relying upon utility companies to obtain utility information at the design phase through the design one call. You've got CenturyLink, one of the largest utility companies, saying our utility information is so inaccurate, it is, and I quote, not accurate to the point that you would use them for design purposes, except they're used for design purposes, which is to say the information from the utility companies throughout the country by public owners as a matter of standing operating procedure. So what do? Let's go forward. Next slide, please. So again, today's a teaser webinar. Sean and I could go on this much more in depth. So we're just going to be highlighting this on a macro level with the notion that, we'll get into this in more detail later. A couple of quick thoughts. One, certainly to the extent that anybody has a relationship with owners, with your state NUCA, we should be encouraging owners, engineers to be using SUE, which is an acronym for subgrade utility engineering. It's a method by way of whereby the owner is at the design phase looking to do a below grade investigation. And insofar as owners are paying for that at the build phase, potholing, for example, where the contractor is called upon to determine the actual location, X and the Y, as well as the Z, since the owner is paying for it, why not get a better ROI by way of doing it at the front end, which then would enable the owner to design around the utilities more by having accurate X and Y as well as Z information, and identify at the early stage of the design, to the extent that you can't design around it, to identify the need of relocation and look to schedule it on a more timely basis. Another really important tool that you, as well as owners, should be using is the utility easement agreements that public owners have. So in other words, when an owner grants the right of a utility to place their line, in an area, along under the public road that's granted pursuant to an easement or utility agreement, which is a document that's standard around the country. And what's interesting, but my experience is no public owners or consulting engineers understand is, I don't know if I would say most, but my experience is many of those utility agreements have language in there that is critical insofar as allowing you to address more effectively the problem of late utility relocation, unmarked, mismarked. Two important characteristics that you find so often in those agreements is, one, a lot of them will provide that upon request of the owner, the utility is required to relocate its line within a defined period of time. So in the big case that I had against CenturyLink, they were required to relocate their line within, I believe it was 15 days upon written request of the owner. So what's notable about that first two is it's the owner that has to request that, not you, even though by contract, typically that responsibility is foisted upon the contractor. It's critical that, one, you as a contractor get that agreement, but two, to recognize that the ability to exercise that request has to come from the owner. Two, a lot of those utility easement agreements provide that if the utility fails to relocate within the time requested, that the utility company is liable for the extra construction costs. So again, it's a really important tool, not only for the contractor to use, but as well as for the owner. And what I really recommend is that before I'm going to any pre-con for a project, I, as a contractor, am requesting copies of the utility / easement agreements from the owner, in order that I have that information before I go to the pre-con. And then when the utility companies are there, to the extent that I've got language like I've said, hey, duty to relocate within a stated period of time, as well as financial consequences if you fail to do that, that gives you a tool as a contractor in your tool chest to be able to potentially minimize utility relocation, notwithstanding that you don't have a contract with utility companies. Okay, gotcha. Next slide, please. And, if I just talked about a tool to use to try and minimize late utility relocation. At the same time, the reality is, even if you have that tool and use it, or otherwise don't have it, the reality is, we're going to continue to, run into problems of late utility relocation. I'm a God-fearing person, and as I like to say, in the hierarchy of life, there's God, and above God are utility companies, and above utility companies are railroads. So if God ain't answering your prayers about utility relocation, it's going to be problematic with utility companies. So what's the strategy that when and if you have late utility relocation, you have unmarked, mismarked utilities? An important takeaway of this: your rights relative to getting compensation vary significantly by way of your contract, as well as state laws. And we could, Sean and I could do a whole separate seminar if we were to focus on what specific states provide on this. I've done a national survey on this before, so I have a pretty good collection of what's there. But for example, a lot of DOT specs provide for compensation for unmarked, mismarked, late utility relocation. Sometimes for the compensability for unmarked, mismarked, it's not expressly addressed, but your right would be set forth in the differing site condition clause. But again, some DOT specs provide for the right to get paid for it. Some standard form agreements outside of the DOT, as well as including the DOT, provide that an owner may be liable to pay for the extra cost related to unmarked, mismarked, late utility relocation, but only to the extent that the owner is quote unquote negligent. And I would offer that I've looked at a number of grounds to show negligence. Certainly one of them that you could and should focus on is if an owner has a utility easement agreement that provides the owner with the right to require a utility relocation with a stated period of time. If the owner fails to exercise use of the rights that are attendant to the easement or utility agreement, I would certainly treat that as negligence, as potentially the basis to get paid if in fact your contract requires negligence. What's sort of difficult and frustrating, but also important to understand, is contractors' right to get paid for these issues, unmarked, mismarked, late utility relocation, often are set forth not in the contract, but rather in regulations. I don't know if I found any in statutes, but certainly I found them in regulations. For example, Iowa has a regulatory scheme work that's set up for Iowa DOT work as an example. And under that regulatory framework, it provides for the right of compensation. The challenge is contractors need to educate themselves, as an example in Iowa, as in every state. What has a state government done that's not set forth in the contract? Again, the news is a lot of states through regulations have provided for a right for compensation for utility-related problems. And in other states, your right to compensation is set forth not in the contract, not in state regulation, but in county ordinances. Some county ordinances, and I got one right in mind right now, a couple of them that I've got contractors paid for it, provide that like some of the utility easement agreements, upon request from the owner, utilities required to relocate within a stated period of time. And if they fail to do that, there's a right for the contractor to get paid for it. So in summary, I guess the takeaway is on this last topic, you as contractors need to get educated in any jurisdictions and when you're bidding and building, that educated on as it relates to this critical issue of unmarked, mismarked, late utility relocations. What does the contract say? And what are the, if any, regulations and or ordinances say? Again, this is a first time addressing an issue that Sean and I should get into more deeply. And with that in mind, I'm going to hand it over to Sean.
Yeah, thanks, Tom. Appreciate it. Let me just first start out by saying that I'm thankful that NUCA is putting this together. I know Tom and I have been talking about doing this kind of seminar on a routine basis for maybe about a year now, and I'm honored to do this with Tom. He's just a distinguished practitioner in the field. I'm hoping it makes my reputation grow just being on the seminar with him. But we've got a lot of good years of experience between Tom and I. And what I would urge you to do is not only to either hit the chat button or email Bob at NUCA with questions that you have today, but all of the things that we're talking about are very factually nuanced. And as Tom said, we could talk probably on any one slide for about an hour. So your questions will probably need potentially a deeper answer. And Tom and I are both committed to answering your questions. So feel free to contact either one of us outside of this seminar. And during this seminar, feel free to ask questions, because that's really the purpose of what we wanted to do, is not to bi-monthly get on here and tell you what we think, but really to engage you guys to be able to control the seminar and us to answer your questions, sort of like a free legal forum, if you will. And to that end, before we started here today, Tom, Bob Baylor, and I were talking about, what the topic should be for the next seminar that we have, and we've decided that we're going to leave it up to you guys, and from now on leave it up to you guys. So if at the end of this you email Bob Baylor at NUCA and let him know what you think the next topic should be, whoever gets the most votes, whatever topic gets the most votes, that's what Tom and I will talk about the next time, so that we keep it exactly relevant to what you guys are facing here today, and really drive home a benefit of being a NUCA member. So keep that in mind. Ask questions today, certainly, but follow up with us and definitely let NUCA know what you want the next topic to be. So with that sort of procedural aspect of what I wanted to tell you aside, I'm going to let you have some more bad news, just following up what Tom said about what can be done and the hurdles that you have to overcome when you've done nothing wrong, but somebody else has done something and it has caused you to have downtime or equipment damage or the things of the like. And the first thing to understand is the economic loss doctrine. So you're out there on a site, you call 811, they mark out where the utility is, it's not there, it's in a new place, and you hit it. The lawsuit that you would typically bring, and I'll talk about the practical realities of whether or not you would go against a utility company that you might be doing a lot of work for, or the third party that might be marking out the utility line for the utility. I know in my region, and I deal with Pennsylvania, New Jersey, and New York, a lot of the utilities themselves will go out and mark their own lines. So it's a direct sort of issue that you might be going against the utility company that's also giving you work. So that's the factor I don't want to lose sight of, and I'll address some sort of practical aspects of what you can do about that. But with that said, there's this concept called the economic loss doctrine, and you'll see on your screen there sort of a definition for economic loss, because you would sue, again, you would sue the person that marked out incorrectly the line location under a negligence theory. And the problem with that is that a majority of the states in the US do not allow a lawsuit to be brought under a liability theory of negligence, which is a tort, and at the same time look for contract damages like downtime. And therefore, as a matter of law, if you're in one of those states, and all the states that I mentioned that I'm licensed in, PA, New York, and New Jersey, follow the majority rule of the economic loss doctrine. And therefore, you can't sue someone for breach of contract and negligence. You'd have to sue them for breach of contract, and you can't sue a party for negligence if your damages are economic. And economic means really what the contract is about, right? So the flip side of that coin is that's why the utility company can always sue you, because unless you're replacing the very line that you hit, when you hit a line, be it a utility line, a Verizon line, a communication line, when you hit that line, that's property outside of your scope of work. And that would be covered under a negligence cause of action. So property and personal injury damage that's outside of your scope of work would be covered, but not purely economic loss. You can go to the next slide, Bob. So therefore, this is the presiding rule in most of the states, that purely economic losses are not recoverable. And therefore, you're kind of trapped when you're in a state that follows that economic loss rule, right? I mean, bringing a negligence cause of action is not going to be what you're going to be able to do. You can go to the next slide, Bob. So there are exceptions to that rule, and I'm just showing you a statute from New Jersey that takes that exception. Here, by statute, they're going to say that the facility operator, next slide, Bob, has the obligation there to mark the utility line, and any underground facility operator that fails to mark or locate that, and I've highlighted the parts that I want to look at, shall be liable for any costs, labor, parts, equipment, and personal downtime incurred by the excavator damaging a facility. So there we have a statutory obligation. If you go to the next slide, and it's reciprocal, meaning that it also imposes upon the contractor the same obligations up to the utility if you do it. But there we've taken an exception to the economic loss doctrine in New Jersey that would allow you, again, to get around the fact that you might not have, a negligence cause of action. So that's just an example in one state, but you've got to be familiar with your own local laws wherever you're working and whether or not they are following or not following that majority rule. Okay, so that is not to say, listen, if you went down, you hit a gas line, and your backhoe blew up because of that, now that would be property damage outside of your scope of work. So that probably would be covered under most instances, as opposed to not being covered, even if you didn't have this exception to the economic loss doctrine. So that's something to keep in mind. Next slide, Bob. So what's the answer here? Because Tom and I are trying to give you practical solutions on how to get around this. I mean, one answer is whether or not you've got a statute in your state, or whether or not you can get a statute in your state passed that would address these issues, similar to the statute that I just showed you by New Jersey. Now, interestingly, that section of the statute in New Jersey, about 20 years ago, it also had a provision in there that said if for any unmarked or mismarked line or utility hitting that happened that was under $25,000, you'd automatically go to mediation, and mediation followed by arbitration, and then the arbitrator would make an award within 45 days of the date of the filing of a demand for arbitration. So that's pretty quick, and that's very timely. Now, unfortunately, that was found to be unconstitutional in the state of New Jersey. And it was found to be unconstitutional because they found that it's really a statutory codification of common law negligence. And in New Jersey, a common law negligence has a right to a trial by jury. And because it was settled up completely in arbitration and had no way to get to a jury, it was found unconstitutional. I raise that because if you're thinking that your state wants to pursue a statutory remedy to mismarked and unmarked lines, you've got to be cognizant of what other states have gone through and the hurdles that have barred them from that kind of streamlined resolution process. And I really do. I think that this might be a legislative answer that's definitely needed in my states that I practice in, where we get to, I like mediation and arbitration with, I guess, a right to appeal to a jury to get around that constitutional issue. But that would give a quick forum for resolution of these issues. It wouldn't be as combative against the person that you have a contract with, because it would almost become like a traffic ticket. And that's the way it was about 20 years ago. Utility companies didn't hold it against contractors for following that forum. It's a quick, easy solution, and you don't necessarily need lawyers. In New Jersey, it specifically said you didn't have to have representation by a lawyer. So that realistically, it's sort of like death by 1,000 cuts. If you're having 1 or 2 hits a week, you know, of these utility lines, and it's 5,000, 10,000, okay, all that builds up to your bottom line by the end of the year. It would be nice to have an ability to get in there and have a statute to address ADR, which is mediation, alternative dispute resolution. If that's not possible, some sort of arbitration and participation in small claims without the need of an attorney. And that's really what I would recommend. And I know my state, New Jersey, NUCA, New Jersey, is looking at that issue. I understand that Nebraska is looking at that as well, but I do think that that is a way to get around it. As we stand here today, I want to share with you a creative solution. I have some contractors as clients that would do this. So what they would do is when they hit a line, they don't necessarily bring an action against the utility because, of course, they're, don't want to bite the hand that feeds it, but they'll document everything that happened and they're going to hold on to it. Meaning they document up a claim and the cost of that claim, and they don't bring it against the utility. They hold on to it. Statute of limitations for a negligence claim in New Jersey is 2 years, and they would file those. And then if they hit a line where the utility was going to go after them for the cost of repair, they use it as a means to settle it out without actually incurring any cost. And I thought that was such a unique, practical solution to this problem, and until you really get a streamlined avenue towards ADR and arbitration, is, again, collect up the documents and the incidents that have happened to you on mismarked and unmarked. You don't necessarily have to bring the claim, but if you hit a line and it's your fault and the utility is going to force you now to pay for all of the cost of that line, now you've got something either to mitigate damages against your own company or maybe to offset it entirely with that. And even if it's a third party marking them out, you can always bring them into the action if it was large enough. So that's another sort of a practical homespun solution to unmarked, mismarked locations, and how to deal with that effectively until we get some legislation in place. So with that said, we've hit sort of the half-hour mark, and I think, Bob, we were going to open it up to questions and answers and see if we can address the things that these participants are experiencing and maybe answer their questions.
Thank you, Sean, and well done on hitting the mark exactly. I was going to applaud you on that. Let's now open the webinar to questions. You can use the chat feature to submit a question, and I will read the questions presented, like I see one person who's already done. Or if you prefer, unmute yourself, state your name and company, and ask the question directly. Remember to remute yourself after you finish. Sean, the first one is, how about the requirement, like in New Jersey, that you must start work within 10 days for the locates to be valid? I heard of a job in New Jersey where they say the excavator did not follow New Jersey requirements of starting within 10 days to keep the ticket valid for the full time. The excavator hit a utility, and this was one of the things stated in a Surface Transportation Board report. How about the requirement like New Jersey that you must start work within 10 days for the locates to be valid?
Yeah, I'm not sure what the question is. I think that is a requirement in New Jersey, and my suggestion to you would be to follow that requirement because it's going to be an issue of whether or not you're negligent. So let me run the scenario and fill in the blanks and hopefully address the question. If it was on the 11th day and you hit a utility line because it was your fault, I think that would go to demonstrate that you were negligent in your reliance on where that location should be and potentially negligent, again, showing sort of a pattern of conduct that you were negligent and not maybe using hand excavation and then using a digging bucket too early and you hit the line when you should have seen it. So it is a requirement. You have to follow it. I would always ask you to, and I do understand the necessity of having, guys out there and not wanting to wait again till they come back out there and mark it again. But I would at least make the call and see if we couldn't get confirmation that you can still rely upon the mark that was made, maybe on the rely upon the call that was 10 days ago if it's the 11th day. Obviously, the longer that you get away from that 10-day period, I think you should call 811 again and get a new mark out.
I guess just to clarify, I guess my question is that valid that they can do that? I mean, like, you got to call them in. They say, okay, call them in 3 days ahead of time. You call them in, something happens, weather, whatever else. You don't get started until the 11th day. You hit a unmarked utility. Can they turn around and say, well, you should have started within 10 days and we marked it, but now the mark is gone and that's your fault I mean, it just seems like, is that really a valid thing that they can hold you to, that you have to start within a certain period of time? Not just within the 28 days, I guess, or whatever the law might be.
Right. It goes to the reasonableness of your actions and whether or not it was responsible. So there's no exact answer. There's no exact answer to say on the 11th day, you're absolutely negligent for having done it. But violating a statutory requirement is the prima facie evidence of negligence, right? So it is not a valid it is not a good starting ground. I'm going to say there may be other facts in your scenario that kind of intervene and would assist you to say, I wasn't negligent and it was reasonable for me to rely upon the mark out. Yes, you could get lucky that way and have those facts. The best practices would be to follow that timeline. Yeah, absolutely.
Okay, so it's common, not just in New Jersey. I think Ohio maybe has it too or something, but is that fairly common what other people are seeing, I guess, throughout the country, that they have these time frames that not only is it just that the ticket's not valid till 2 or 3 business days, whatever, and it's good for 14 or 28 days, whatever it may be, that they also, do many states have a requirement that you must start excavation within a set period of time, even if it's before the ticket would expire? Is that common?
This is Olson, yes. And what that's driven by is the notion of trying to confine the period of time when it's reasonable to rely upon that information to one that's limited, with the notion that going forward there might be more utility lines that are put in. So the idea is we want to limit the time within which that reliance on that information is treated to be reasonable. And unfortunately, throughout much of the country, it's defined by time. So
Okay.
it's an unfair position that even if the requirement, for example, you're going through with Sean is 10 days, on the 11th day, you're saying what's changed. And unfortunately, as Sean said, also the problem is what changes now. If you rely upon it, you've breached a regulatory statutory obligation. And as Sean said, you're coming in as a negligent party trying to, address an issue where you're failed to do what you're required to do in it. So the moral of the story is do what you're required to do, because unfortunately, sometimes the consequences for not doing it, as unfair as they can be very real, like on this issue.
And let me follow that up with a sort of a hypothetical, right? To kind of demonstrate that. So let's just say you were driving down the road and you're doing 90 miles an hour in a 45. And a police officer tracks you doing 90 in a 45, and he's going to cite you for that speeding violation. And at the same time, you run into another car and damage that car or hurt that person. You're in a much worse position to argue, I wasn't negligent and the other guy caused the accident, because you've been going 90 miles an hour in a 45. Now, it could be that the other person did cause the accident and you had nothing to do with it. If we looked at it in a crystal ball, we could hypothetically say that you had nothing to do with causing the accident, and therefore you shouldn't be liable for the damage of that other person's vehicle or person. But the reality of the situation is you're playing out this game of, was I negligent or not negligent, to a judge or a jury. And that the violation of that speeding law will be prima facie evidence that you, in fact, were the negligent one in the accident. So it gets tied together that way. I hope that example, that hypothetical, helps you think about, while, you know, start to work within 10 days. It doesn't seem reasonable because what's really going to change? But it is the legislature trying to put these parameters and limitations on the timeline of what will be reasonable to rely upon before you have to call them back out.
Thank you, Sean, and thank you everyone for submitting questions. We're going to try to get to as many as we can today. The next question is, to what extent can you address the third-party bill collector type of companies that file a claim directly against your general liability insurer?
You want to go, Sean? You want me to go?
You can take it, Tom, or
Yeah.
why don't you start?
Yeah. So, and unfortunately, that's such a very common tactic. Was you get inaccurate utility information, you hit the line, and then X number of months later, you're getting called up by a collection firm. And even on top of that, I know in some states, if you fail to pay when requested, the utility company will go to the Better Business Bureau and use really punitive tactics. You know, what I say to contractors, one effective way to protect against it is when you have a utility hit that results, you need to document right away what's happened. To the extent that the utility hit was caused by getting inaccurate utility information, you need to document it right away, and as much as possible try and get agreement on the job site, and prepare. Talk to the people that are there. I mean, I've had enough projects where the utility company will, a representative, when you finally can get them out there, will agree it's not where it was marked, or you get the consulting engineer for the project that'll say, I agree, it wasn't where it was marked. You want to have those conversations with those people and then reflect the conversation in a letter that not only goes to the project engineer, but also goes to the utility company. And then I always like to have some magic language at the end of it. If your understanding is different, let me know in writing immediately. Otherwise, I'm going to proceed on the basis it's accurate. And then when you get that request for payment X number of months later, you're better protected to say, hey, look, that wasn't my fault. So that's certainly one piece of advice that I've given contractors that's been very effective.
Yeah, I'll just add to that I think, sometimes these third-party collection firms that are going to come out there and try to make a claim and then hound you with these letters and reporting to your carrier and everything else, it does present a opportunity in this way. Remember, I said in my presentation that I have some clients that will collect up when there's an unmarked, mismarked location that's not their fault against a specific utility. And for a utility that doesn't already have in-house counsel, up my way on the East Coast, some of the larger utilities have a legal department that will do all of this collection work for them, and it's not as effective in that situation. But when you go to a collection firm, let's think about it. You're going to give 20, 30, 40% of what's owed already to the collection firm when they collect on it. So again, if the collection firm is reaching out to you, I would reach out directly to that utility company. And again, if you've got a list of situations where they were incorrect on marking things out, and you can sort of trade and mitigate what the damages are, you can either again get a walkaway going because the collection firm can't stop that, or you can have this reduced to some de minimis amount, meaning if they think you owe them $25,000 and you've got mismarked locations where they were at fault for $20,000, well, then you're going to pay them $5,000 and get rid of the collection firm, who will get like $1,000 out of that instead of something more substantial. So it is everything. Every detriment is an opportunity as well. So when you get those collection letters, again, if you've done your homework and you followed and you can follow up with them, I think it's an opportunity to resolve it quickly.
If I can add one more thing, harkening back to something I said, which is utility companies have inaccurate X and Y information and literally no zero information. In a lot of states, your liability for hitting a line is tied to negligence, and so one way to respond to it too is, hey, look at how can I have been negligent if there's no information given as to the vertical location, which is to say the Z information. Again, there's a lot of tools that really Sean and I are offering that really we want you to listen to as being tools that you can and should use to proactively resolve the issue on a job site rather than having to do it in a courtroom. And if you listen to that filter, hopefully it will empower you to approach the same thing differently going forward.
Our next question is from Pablo. What about when you hit an existing utility that has less than 18 inches of cover in areas where all utilities are to be deeper than that? Why should they be responsible if the other party is not compliant with regulations from the beginning?
I'll just jump in a second. I've had that happen, and we've been successful in not having to pay for it, as well as on some jobs having it be a basis for us getting compensated as being a differing site condition, because as the Pablo said, normally you have an appropriate vertical elevation at which the line should be placed, and the one that comes to my mind that most recently happened was when we were tearing out asphalt. The utility line was actually within the asphalt pavement when we hit it. So, yeah.
Yeah, I agree with Tom there, and it's almost the flip side of the first question that was asked about, a time limitation on reliance on 811 when they mark it out. There, you've got someone who I think is clearly acted negligent because they put it into an elevation that it should never be, and therefore I think that's a very strong case. But again, negligence is a very factually nuanced cause of action, so it's always different. It's always there are circumvening events that can make you negligent or relieve you from liability, sort of exculpate your responsibility. So it's factually intense, and you've got to really understand the context in which the incident happens to know whether or not you're responsible.
Next question is from Kurt. Can you address more specifically how the economic loss doctrine would apply if the damage occurred on the project site versus not applying for damage outside of the site? Are we talking on-site, off-site, or damage that you create liability to a third party?
Yeah, it's a great question. It has nothing to do with the location on the project site, meaning on someone's facility or in the middle of the road, kind of on a major highway or anywhere else. The concept really started, economic loss doctrine started with nothing to do with construction, by the way. It had to do with products liability actions. And what the courts have said is, listen, the kind of a negligence cause of action has damages that stop. Someone's not going to get injured and be more injured from that very accident the next day. They're, to the extent of their injury, it's there. Coupled with that, parties should be free to negotiate the risk that they want to take, because when they enter into a contract, they're free to sort of agree and disagree as to the limits of their liability or the full extent of the foreseeability of their damages. So with that context, it's a preclusion from suing someone for negligence. Again, that's that common duty that we all owe each other in the world as acting as rational beings. So it's a limitation on suing someone under the theory of negligence, but your damages being economic. And the economic damages are like contract damages. So when you're hit a line and you want to sue a utility or a third-party provider who marked it out incorrectly, for example, when you've got a crew that's out there for an entire day doing nothing, those damages, the wages of those individuals that are sitting there, are economic. They are the labor component of the price in your contract. So they're economic damages, yet you're going to sue somebody, the utility company, the third-party provider, saying you were negligent because you should have known where your line was. You told me a different location and I hit it. So it really has nothing to do with geography, which is what I understand the question to be. It's more substantively on what types of damages you're looking for in relation to the cause of action that you have.
Next question is from Kemp. What happens when paint was not down by day 10? The locator has already put us behind that 10th day. Can another utility hold us liable, being that they located as requested by their timeline? What happens what happens when paint wasn't down by the 10th day?
So you're saying you made your build, your dig one call request, and you don't get the information within the window, or you get the information within the window, but by the time you go to do it, the paint's gone.
No, the paint wasn't down at all by the 10th day. Can another utility hold them liable, being that they located as requested by their timeline? I read the question correctly.
So is it unbeknownst to you, you do your build one call, and one of the some utilities give the information, paint it, flag it, however they're going to do it within the time, but one of the utilities does not?
I can't tell by the question, but it's a good question.
Yeah, I mean,
Correct.
I might offer.
Correct.
Yeah, I mean, part of the problem is you're assuming that you're going to get, in response to your dig one call, accurate information. Let me just offer, and I don't know if this is answering it, but it's important recognition. The reason that you have so many problems with utility hits when you do your build one call is you're getting the same information at that phase as the owner got at the design one call phase. So if it's incomplete, inaccurate information at the design one call phase, so for example, doesn't accurately show up in the plans, you're going to have the same inaccurate information at the build phase, the same information, i.e. what the utility company's provided to the owner. At the design phase is the same information that utilities, through whatever the service that you've got in your state, are going to be providing to you at the dig phase. So if the problem's going to go on, and insofar as you proceed on the basis of assuming that you've got utility information that it's not there, you've done your proper utility one call. If you hit the line, that shouldn't be negligence, because you had a right to rely upon the information being provided. If the utility failed to do it within the regulatory time frame, then you had a right to proceed on the basis as though you got accurate and complete information by way of the utility information that was painted or flagged.
Sean, this one's for you. Why is it that New Jersey DOT smart highway and intersection lighting are not included in the one-call markout system?
Why is it that they're not included in the one-call markout system? I don't know. I don't know why that is. You've stumped the bad. I don't know.
Next one's more of a request. Please be careful when you discuss 811 and marking lines. 811 services do not mark the lines. The utility owners or their contract locators do the marking. Are there any other questions? You can either submit it by chat, or as you saw, you can unmute yourself, state your name and company, and ask the question.
While we're waiting, if I can offer something.
Absolutely.
I think it's important to listen to what Sean and I are saying, mindful of what's a strategy that I can use, which is to say the approach the same thing differently to get a different result, that I can utilize on the job site, not in a courtroom. The art form is resolving it on the job. I mean, in a courtroom, it's cavemen with clubs. So really, it's how do we refine our best practices to get better to address, the all too often problem of unmarked, mismarked, late utility relocation. I can't emphasize, it starts with, you got to get educated on what, your standard form contracts say about this issue, as well as the state laws, county laws in which you're working in. Once you understand that, then it really educates you to help resolve the job site level. The next thing is, from my standpoint, if you take nothing more away from what I've said, it's the use of easement utility agreements on the job site. And again, feel free to follow up with questions about that. But what I can tell you is, having spoken on this topic before, when I was at one DOT conference with agency DOT conference, and talking about the use of this easement utility agreements, I had one large contractor say, I use it on a regular course right now. It's been a game changer in terms of minimizing the problem of unmarked late utility relocation, because to the extent that so many of these agreements provide the obligation for relocation with a stated period of time, as well as an obligation to pay for the related extra costs if utility fails to do that, that contractor has gotten a whole different result in terms of getting more timely utility relocation, utilizing those agreements as a regular tool in the tool chest.
Thank you, Tom. And I think that's probably for questions. Thanks everyone for your questions. You can see Sean and Tom's contact information if you need it. It'll be provided on the PowerPoint, which I'm about to post. Let's go and wrap this up. Tom and Sean, thank you very much for your time today to lead this important discussion. We'd also like to thank our many national partners for generously supporting NUCA and our monthly webinar series. Today's webinar has been recorded. A recording of this webinar will be made available on the nuca.com website and our YouTube channel over the next few days. And like I said, I will have the PowerPoint up as a PDF probably within the hour. Thank you for your time today to join us for this special industry webinar and supporting NUCA. We welcome your suggestions on future topics. You can email me at robert@nuca.com with your topic suggestions for our future episodes. The next construction law webinar will be held online May 23rd. The committee, however, will be meeting at the 2023 NUCA annual meeting March 13th in Las Vegas, Nevada. Please note that session will not be recorded, so we urge you to register for the annual meeting at nucadigs.com to attend in person. Thank you for your time this afternoon, and please enjoy the rest of your week.